record. Good afternoon, everyone. I'm Judge Jackie Powell. This is First Appearance Court. And this afternoon, I'll let you know if I've determined probable cause based on the police reports I read this afternoon. And then we will talk about release conditions. Today's not your trial date, and so I encourage you to speak with your attorney before speaking on the record. Some of you, those of you charged with misdemeanor cases or municipal ordinance matters, if we have those can be resolved at first appearance depending on what's going on with you personally. Any other matter, felony matters or violation of felony probations, those matters you must go before your division judge to resolve those matters. All right, we have first on the docket, Latoya Harris.
Judge, I've been informed she bonded.
All right, Ms. Harris bonded. I find probable cause. Faith Leffler.
I've been informed she bonded.
Ms. Leffler bonded. I find probable cause. Terrence Hall.
North Broward.
All right.
No contest.
Mr. Hall, you are before the court for a KPS that was issued December 12th, and the charge there is trespassing. This is an ad charge, so what else does Mr. Hall have?
Mr. Hall advised me, Judge, that he was ROR'd on count 1, which was a possession of cocaine charge.
Okay,
And it looks as though counts 2 and 3, which are also trespass charges, he received time served. I'm not showing that he was ROR'd on count 1, so maybe we could ask confinement status to verify his status.
all right, sir, I am going to ask you to hang on a moment. We all can't talk at the same time, and whatever the answer is, we will get to it, okay?
Yeah.
All right, ma'am, what happened on charge number 1? Mr. Hall, when did you receive the ROR on the?
The next day, November 25th, they ROR me. They gave me 30 days county time. It was whatever. She said, Judge Glazer. I got it right here on this print.
Judge who?
Glazer, I believe.
Judge Glazer is in Miami.
Yeah. Well, it was one of these judges, misdemeanor on the weekend. But she let me.
You have the case number, Mr. Reedy? All right, sir, stop talking for a moment. Mr. Reedy, you have the case number? On the charge that he's saying he was ROR'd? Was he in? Okay. I just need to know what happened with it. Does he have a bond? What's going on with that? Okay. Okay. Okay, all right. So we've looked at it, and you have $1,000 bond on that case. You were not ROR'd. And so I find, okay, he's got a $25 bond or a $50 bond, whatever it is. Okay, Corey Love.
How you doing, man?
Hi, Mr. Love. You're before the court today. These are for 2 additional charges. Charge number 8, dealing in stolen property, and number 9, false owner info for pawn items. I suspect Mr. Love is in on other bond amounts.
Yes, Your Honor, he has a $10,000 bond on count 1 and a couple of $3,500 bonds and a couple of $1,000 bonds, and he is asking if the court would consider reducing the bonds on count 8 and 9 from $3,500 to $1,000.
All right, I'm going to deny it this time and leave the bonds in place, okay? Fabian Clark.
Mr. Clark has some family here.
Okay. Or is he at the main?
Yes, ma'am.
All right, Mr. Clark is before the court this afternoon. Charge 1 is resisting officer without violence. Number 2 is possession of burglary tools with intent to use. And number 3 is burglary of an occupied structure unarmed. I find probable cause for these charges. And I'll hear from the parties at this time.
Judge, and speaking to Mr. Clark, my understanding he has no criminal priors. He's a registered voter where he lives. He's from Tampa. My understanding, Judge, is in Tampa he works. He works as a valet driver, and he lives with his mother. My understanding, Judge, is that I did advise him that if the state files charges, he will be receiving a notice in the mail when he has to come back to court, and he will be appearing back in court. I believe his mother and his stepfather are there present. He's going to be relying on them to post a monetary bond. If the state can confirm he has no prior record, I'm going to be asking for a $1,500 bond on count 3, Judge, and a photo order as well.
Okay, state?
Says, I did look up his history quickly. I could not find anything. In regards to the bond, Your Honor, on count 1, I believe I would agree with the convenience bond. Count 2, I agree with the convenience bond, and on count 3, I would just ask for a $2,500 bond on that count.
Okay. All right, good afternoon, folks. Is there something you wanted to say?
What drove him to Fort Lauderdale, he did hit one of our vehicles, and he was afraid to tell us. Tried to find the park because it was the only place that had the park. He was at the facility, and I know he's a college student. He's going into his senior year. I'm not really sure if this is going to affect his future, what's going to be on it. I mean, I understand wrong is wrong, whatever may have happened, because I wasn't really there. And my son is accountable for any actions that he has done, but I'm asking for his future, what can be done to rectify this and give him a chance. Because he is honestly a good kid, but because of my strictness, he was afraid of me to come to me, to tell me what happened that put him in the situation. But like I said, wrong is wrong, but I'm asking what can we do for him to maybe protect his future?
Well, this is his first appearance. This is not his trial. For this hearing, the determination that I'm making is, does the facts that are presented to me, does it meet the elements for probable cause? And then to consider, the bond amount. After today, he will have a time when, if he's going to go to trial, he's going to have his day in court to be able to put on his defense.
How do we rectify the bond? Because we were
Well, that's why we're here, and that's the thing that I'm considering at this point in time. But he is 21 years old. He is not a 10-year-old.
no, he is not,
So-
and he knows that.
So, well, I hope he knows that, right? And,
He's mostly respectful to us, but like I said, I do hold some strict rules that has made him.
but my point is that for you to say that because he was afraid to tell you that he damaged a car, that this led to what I'm reading here, does not make any sense for a 21-year-old. That's what I'm saying. All right? But I do hear that he's not had any priors before. And are you both here to, are you willing to post his bond?
Yes, we have 1,000, but that's what we were told it was over the phone.
No, well, actually, at this point, I have to put a bond on charge number 3. He has a total of 1,100 already, and the bond has not yet been imposed on the burglary of the structure. That needs a bond at this time. So it is going to be more than $1,000. You're saying he does not live in the Tri-County area?
No, we're from Tampa.
Okay. All right, so,
I will hold responsibility for him as
Well, ma'am, you know, you shouldn't have to be responsible for the children when they get older. They have to be able to stand up and face their own issues. So I will impose $1,000 bond on charge number 3, and so he'll have a total of $2,100 in bond, and no return to this location. All right? No, ma'am. Everything is here in Broward. He's gonna have to come back to court here in Broward. That's why I can't put him on pretrial, because he's not within the Tri-County area. So whenever there's a court date, he has to come back here to Broward County, okay? All right. All right, Brandon Goss.
Mr. Goss is approaching. Judge, he's here at me. Come on up, Mr. Goss.
Mr. Goss is before the court on one charge of possession of methamphetamine. Number 2 is possession of drug paraphernalia. Number 3 is trespassing. I find probable cause.
Judge, nothing to add from the defense.
All right. So I'll leave the standard bond in place.
I'll call your parents as soon as you get out. No problem.
Ryan Culpepper.
Mr. Culpepper, come on up, please.
All right, Mr. Culpepper is before the court. Charge 1 is sexual battery on a victim 18 years or older by a person over 18 years. And number 2 is touch or strike battery. I find probable cause for these charges. I'll hear from the parties at this time.
Judge, I understand that the allegations are serious. Having said that, and speaking with Mr. Culpepper, his prior record is minimal. My understanding is the last time he had any sort of contact was probably about 4 years ago on a misdemeanor offense. Now, in speaking with Mr. Culpepper, he's 33 years old. He's been here in our community for about a month and a half. He's from Melbourne. He's attending a local treatment center where he's able to basically go there through his, I believe, family's insurance, and he's there on a voluntary basis. My understanding, Judge, in speaking about Mr. Culpepper's finances, my understanding he's not working. He owns no sort of property. He has no money in the bank. He's going to purely be relying on his family, specifically his father, to help post his monetary bond. But he is from Melbourne. So, Judge, I'm asking you to take that into account in determining reasonable release conditions for Mr. Culpepper.
State?
Thank you, Your Honor. From his record starting in 2005, Your Honor, I see a reckless driving adjudication withheld, a 2007 resisting without violence adjudication withheld. That was in 2007. Continuing, I see a 2010 grand theft adjudication withheld. I see a 2011 sale or delivery of oxycodone adjudication withheld. And then I see a 2018 resisting without violence, and I also see a 2018 petty theft property over 100 less than 300 adjudication withheld. Looks like that one was in Brevard, the last one with a disposition according to Florida CCAS on December 13 of 2019, which was just recent. Based on the facts of the case and the seriousness of this
Where? In Brevard?
Brevard. Your
Okay.
Honor. And the disposition was on 12/13/2019, according to Florida CCIS.
Okay.
Based on the facts of the case and if the court has found probable cause, I am going to ask for a high bond on this matter. I'm going to ask for a $250,000 bond on count 1, and on count 2 a $50,000 bond with level 1 pretrial if the defendant is released, no victim contact, no return, and no contact with the co-defendant.
Right. These allegations are quite egregious, and Mr. so having reviewed this probable cause affidavit and the court finds that the allegations in this probable cause affidavit is quite egregious. I am, and also considering Mr. Culpepper's history, it looks like these parties were, I don't know, if it's clear that they were all staying at, it's a treatment center that they're all at. I am going to impose a $150,000 bond on charge number 1, 50,000 on 2. I'm ordering no victim contact, and that means no phone calls, no text messages, no social media, no third-party contact. If Mr. Culpepper posts his bond, he will be on a level 1 pretrial supervision.
Judge, what was the bond on count 2?
150,000.
That was, I'm sorry, count 2 was 50 and count 1 was 150, Your Honor? Or,
150, yes, a total of 200,000.
and I'm just requesting no co-defendant contact.
And no contact with your co-arrestee, sir. All right. Joseph Naidu,
Judge, is your president, I believe he has private counsel.
okay. Good afternoon, Mr. Lyford.
Ryan Lyford for Joseph Naidu. This is the alleged co-defendant from the case you just heard prior.
Okay. All right, so Mr. Naidu is also before the court on sexual battery of victim 18 years or older. Number 2 is touch or strike battery. I find probable cause for those charges.
Your Honor, I've been in contact, may I, Your Honor?
Sure.
Thank you. I've been in contact with Mr. Naidu's mother throughout the day, and it's been represented to me that Mr. Naidu has absolutely no criminal history. I don't know if the state has had an opportunity to look into that. Mr. Naidu generally resides in Maryland. He was also at this Evolutions facility voluntarily. He was scheduled to basically go home today. I believe he had been there since October. He's a full-time college student in Maryland. I believe he resides with his grandparents there. And if you read the court has read the probable cause affidavit, I would contend that the co-defendant, whose case you just heard just prior to this one, is the more culpable of the two parties. I would contend that a reading of the probable cause affidavit doesn't indicate whether or not my client was even aware of what Mr. Culpepper was doing as it relates to the alleged sexual battery. In any event, with respect to his lack of criminal history and the fact that he's 20 and I think the co-defendant was in his 30s and has a lengthy criminal history, I would ask the court to impose a reasonable bond in this case.
Your Honor, I could not find any prior history in Florida CCIS. The court has found probable cause affidavit. I'm going to stick with the same recommendation to the court as the co-defendant. They were both involved in this matter. I'm going to ask for, again, for count 1 to be 250 and count 2 to be 50,000 with no victim contact, no co-defendant contact. I'm not sure if he is going to be able to post a bond, if level 1 pretrial will be able, because as defense counsel stated, he's from Maryland.
He is.
So he wouldn't be able to be on pretrial on that. So if the court is going to lower it to 150, I will ask the court to take that into consideration, that he is not from Broward County and is a flight risk.
Judge, he has significant contacts to Maryland. He's from Maryland. I've been in contact with his mother, I'm told, is going to be posting the bond on this case. And again, he's a full-time college student in Maryland. So, and I'm going to be representing him. So, yeah, he's not necessarily a flight risk in this case. And again, look at the levels of culpability as it relates to the co-defendant, and again, his lack of criminal history. I ask the court to take those things into consideration.
So it is, the report says that Mr. Culpepper was the one who used whatever the weapon is on the victim. It also says that Mr. Naidu was the one who approached a witness and told them that you didn't see or hear anything. So that would suggest that he was there or knew what was going on.
As it relates to the, specific allegation of sexual battery, not necessarily, a battery.
No, I know what you're saying, but, I'm just pointing out that after the fact, he's also saying, telling someone else that you don't see or hear anything. Taking into consideration the fact that he has no priors, I am going to, I'll do $75,000 on charge number 1 and $50,000 on 2, and then no victim contact, and no contact with his co-arrestee. Okay? All right.
Joseph, I'll be in contact with your mother, okay? Thank you. Thanks.
Jeremy Gassett.
Mr. Gassett, come on up, please. He's approaching, Joy.
Mr. Gassett is before the court on 1 charge of grand theft auto. Number 2 is carrying a concealed firearm. I find probable cause.
Judge, at this time, nothing to request.
All right. Standard bond will remain.
I'll call your mom.
Fernando Yee.
Mr. Yee bonded, I've been
All
informed,
right,
Judge.
Mr. Yee bonded. I find probable cause. Thank you. Tyrone Torres.
Medical.
Medical reset on Mr. Torres? Yes.
Hold on, Judge.
Medical loan. All right, and Bartavius Hunt.
He's present.
All right, Mr. Hunt is before the court on 1 charge of burglary for dwelling or structure. Number 2 is possess, receive, or retain stolen or credit or debit card. I find probable cause. Does anyone wish to be heard?
Can I just have a moment to review,
Sure.
Your Honor, please? $19. I just have to look up one. I apologize. Just one more
No
moment.
problem.
Are you finding just for burglary of a conveyance, Your Honor? Or am I missing? Because it's coming up on my PC as armed burglary. Unless I'm missing something.
All right, let's look at this again. This is one of those where the complaint affidavit says armed, well, oh no, this both says armed. All right, defendant attempt to vehicle, to commit witness. He's seen trying car doors on a Hyundai Santa Fe belonging to victim Samantha. Upon making contact, the eyewitness positively identified the victim did not give permission. He found, he was found with credit cards from, of, that came from a vehicle, somebody who lives close to where he was found. So it's not armed. I don't see
I
anything
don't
for
see
armed.
that either.
No, did I say armed?
Yeah, I was on
I'm
the
sorry.
phone, Judge, I'm sorry. I didn't see
Okay.
anything about it being
No.
armed.
So you're,
You know, I probably didn't say the armed, and I was looking again to see why it said no bond. But no, it's not armed. It's
So-
just burglary.
conveyance?
Yes, burglary for
Okay.
conveyance.
Your Honor, I do also see that he does have another open case just very, very recently.
Okay,
It's case number 1614167 CF108. It's a robbery by sudden snatching. The defendant, it looks according to Odyssey, was arrested on December 2nd, 2019. And a bond was posted of it looks like $3,500 and no return, and now he has picked up another felony. I'm asking two things from the court. Number one, if the court's going to set a bond, has to set a bond on this case, I'm asking to revoke the bond on the first case based on him picking up a new crime and hold him no bond on 1914167 CF108 and have it placed on Judge Casey's docket, and Judge Casey could address the issue if he wants to give him a bond on that case again. And if the court is not inclined to revoke the bond on this case, I'm asking the court to give a higher bond on this amount, more than it would usually do on a third-degree felony on this matter. So, based on that, if the court is not going to revoke the bond on count one, I am going to ask for this case, a $15,000 bond on count one, and then a $5,000 bond on count two with level one pretrial, if that's what the court's direction will go to.
No, the only issue is, on the other case, is that finding of revoking the bond has got to be sua sponte. And once you ask me and we go into this communication, it's just, you know, there's now going to be the appearance that it's not sua sponte. So I'm not going to do that at this time. All right, so as to the charge number one, I will impose a $15,000 bond, and he has a $1,000 bond on two. Okay? All right, let's go to the hearing docket. Albert Stanley, this is on the felony hearing docket.
Copy, Your Honor.
All right, Mr. Stanley's before the court. He was arrested November 9th. Has the information been filed on Mr. Stanley's case?
I'll check one more time, but last time I checked, Your Honor, it has not been filed.
Okay,
And I checked again, nothing.
all right, so Mr. Stanley's entitled to an ROR. I'll sign that order at this time. And Mr. Stanley, just so
Yes,
you
ma'am.
know that even though you're being released at this time, it does not mean that the state cannot file the charges after this. And so you have several responsibilities. One, to stay in touch with your attorney, and/or to check the clerk's office to see if you have to come back to court. And also, it is your responsibility to make sure that the clerk has the correct mailing address for you.
Yes, ma'am.
All right?
Yes, ma'am.
Okay, Anthony Haney?
Paul Run.
All right, Mr. Haney was arrested on November 17th. Has the information been filed?
Last time I checked, there wasn't it. I'll check one more time.
There it goes.
No need to say anything, Mr. Haney.
I don't see anything in our end, Your Honor.
All right, thank you, Counselor. So, Mr. Haney, I'm granting the ROR at this time. I'll sign that order, and also, just in case you didn't hear with the previous person, it doesn't mean the state cannot file the charges after you've been released. So you have a responsibility now to stay in touch with your attorney or to check with the clerk's office, and also to make sure that they have your correct mailing address. Okay?
Yes, ma'am.
All right, sir.
All right, good luck, sir.
Leandric,
Thank you.
Also North Broward,
Leandric Osborne,
North Broward, Judge.
thank you. All right, so Mr. Osborne was arrested on December 16th, so he's back for a second look at his bond status. It looks like he has a total of $2,500 in bond.
Yes, Judge, he's not able to post that monetary bond. He is requesting that the court would consider pretrial release for him. He has been a resident of Florida all of his life. He's indicated to me that this is the first time that he has been in jail. So his contact, if any, with the criminal justice system in the past is minimal. But at this point in time, unfortunately, he's not working. He's trying to get back into school, and he would be living with his mother.
All right, state, does he have any priors? No record? And where does he live with his mother now?
What city do you live in, sir?
Fort Lauderdale, Florida.
And so you have a permanent address with your mother?
Yes, ma'am.
How long have you been living there?
My whole life.
All right, I'll release Mr. Osborne to level 2 pretrial supervision.
Thank you, Judge.
All right. They will, pretrial will do the interview and come out to put the ankle monitor on you, okay?
Okay.
All right.
All right, don't miss court, Mr. Osborne.
Jonathan Marion,
Okay. Thanks.
All right, good luck.
all right, so Mr. Marion was arrested December 17th, so he's back for a second look at his bond status.
That is correct, Judge. My understanding he has 2 counts of unoccupied burglary of structure. One is structure, one's a conveyance. He has a total of $5,000 bond. He's financially indigent. He's homeless. He gets disability, but there's no one that's going to be able to afford to post his bond. He's asking me to request a pretrial release on his behalf, Judge.
What was, Mr. Marion's, priors?
There's a long history. I'm just confirming his birthday of 11/15/1977. And it looks like he has, according to Florida CCAS in 1996, Burke structure / conveyance dwellings occupied, adjudicated guilty, grand theft in the 3rd degree, adjudicated guilty. 96, again, Burke structure / conveyance / conveyance dwelling occupied, adjudicated guilty, and grand theft, adjudicated guilty. Same charge, Burke structure / conveyance dwelling occupied, adjudicated guilty, dealing stolen property, adjudicated guilty. 2 counts of grand theft, adjudicated guilty, those were in 96. Again, Burke structure / conveyance dwelling occupied, adjudicated guilty, grand theft, adjudicated guilty, that was in 96. In 96, again, he had a home invasion robbery. 97, Agbat on a 65-year-older, adjudicated guilty, false imprisonment, possession of cannabis, and paroling loudering, adjudicated guilty. Does the court want me to continue, or?
So I left, I'm sorry? Is that a 2017 case? All right. So, I'm gonna deny the ROR and the bonds will remain in place, okay? All right. Oh, and then on our misdemeanor docket, Jonathan Marion.
Judge, I think that should be deleted. When I checked in Odyssey, I believe he resolved that municipal ordinance yesterday.
Okay. Gilbert Hinton. Okay.
Yes, ma'am.
All right, so Mr. Hinton was arrested on December 2nd. Is it a municipal ordinance matter?
Would appear so, Your Honor.
Well, what happened with the Capias? There was a new arrest and then there was a Capias.
They got time served, ma'am.
On the Capias matter, you got time served?
Yes, ma'am.
All right, so why didn't you, okay, well, I guess it's not filed yet. So what do you want to do with this one?
I would like to resolve it today and go home as
All right,
possible.
all right, Mr. Hinton, I'll sentence you to time served. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, sir, you can put your hand down. And do you understand the offer that has been extended to you to resolve your case?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with an attorney?
No, ma'am.
And
I
you-
just, what I wanted to, no, I don't need to talk no attorney. I'm good just as long as I know I'm going home today.
All right. You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea, Mr. Hinton. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck, sir.
Thank you, ma'am.
Stephen Morris? Huh? Yes, thanks.
I believe he's in the main jail, Your Honor.
All right.
He's approaching, Judge, municipal ordinance.
6 months to
Come on
pay
up.
the court costs. All right, Mr. Morris,
He's approaching.
Yes, ma'am.
all right, so Mr. Morris, was before the court on, he was arrested December 16th, so December 17th. He had a lot of, municipal ordinance matters. Have you gone to court on anything yet, Mr. Morris?
Yes, ma'am.
And what happened?
I got 3 to 4 days, something like that.
Did you resolve anything?
Well, I spent my 3 or 4 days, and then they brought me down here to see you.
Do we have any information, confinement, that he's resolved anything? It looks like he's got 3. Okay. I believe this was the one that Mr. Shade said that there was no offer from the city and he was gonna go see him, but is it only these 3 cases that are there? All right, so he was arrested on the 16th, 18, 19. There's 4 days in. Mr. Morris, do you wish to resolve your case today?
Yes, ma'am, I would love to.
All right, so you've been in now 4 days. I'm gonna sentence you to time served. Do you understand that?
Yes, ma'am.
All right, so please raise your right hand. Do you swear or affirm, as best you can, do you swear or affirm to tell the truth?
Always, ma'am.
All right, you can put your hand down. And Mr. Morris, do you understand that you're resolving your case today?
Yes, ma'am.
Is anyone forcing you to do that?
Our Lord Jesus Christ.
Well, aside from Jesus Christ, is anyone forcing you to resolve
No,
your
ma'am.
case? Okay, all right. All right, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes, ma'am. Born in the state of Illinois.
What plea do you wish to enter? Guilty or no contest?
No contest, ma'am.
All right. So I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served. Mr. Morris, don't go back to this place that you've been trespassed from. All right?
Yes,
All three
ma'am.
counts. Okay? All right,
ma'am.
all right, sir. Good luck.
Thank you.
Michael Tapia?
This is the one of those days.
How are you today, ma'am?
Hello, Mr. Tapia. Mr. Tapia is in the same situation. He was arrested 4 days ago. It was the city of Fort Lauderdale, several municipal ordinance violation. Mr. Tapia, did you go to court yet on any of these matters?
Same as Steve did. I made 3 days ago.
Right.
Something.
So I'm the only judge that you've seen since? You haven't seen another judge? That's my question. Have you seen
ma'am,
another
I haven't.
judge?
No, ma'am.
Okay. All right. So, Mr. Tapia, I'm going to tell you the same thing that, wherever you've been trespassed from, you can't go back there. Do you
Okay.
understand that?
Yes, ma'am.
All right. And I will sentence you to time served. So please raise your right hand if you wish to accept that. Yeah,
I do.
as best as you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And Mr. Tapia, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
I understand.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
I understand.
All right,
I
Mr.
was born in Baltimore.
Okay. So, Mr. Tapia, I accept your no contest plea. I find that it's freely and voluntarily given. I'm sentencing you to adjudication and time served. I'll give you 6 months to pay your court costs. Mr. Tapia, I'm asking you not, I'm ordering you not to go back to this place. If I see you again, I am going to remember, and the probable cause affidavit is not very cute about, what you and the other gentleman keep doing. So don't go back there. Do you understand that?
I understand.
If you need help with housing, and I should have told the other gentleman that it's the city of Fort Lauderdale. Well, this week, you're gonna be out for the next 2 weeks, but they do have community court every Wednesday, except on holidays, and unfortunately, the next 2 holidays fall on a Wednesday.
Wednesday.
But even if you don't have court, you can show up at the city of Fort Lauderdale when they have community court on Wednesdays and get help, that whatever help that you need with housing or health or anything like that, all right? So I would encourage you to take advantage of whatever help there is so that you don't have to keep coming back here. Do you understand that, sir?
Yes, ma'am.
All right, good luck.
Thank you.
All right. Paul Acevedo,
I'm free today. Yes.
Mr. Acevedo indicated to me he'd like to resolve this matter today if possible.
all right, Mr. Acevedo has a petty theft charge. And State, do you have any offer for Mr. Acevedo? I don't have a copy of the proper cause affidavit, so
See if it's a store.
I'm not sure what the circumstances are.
The affidavit, and I saw that he came in on a probation violation under 198245 CF10A. Let me check. this would violate his probation, so
Well,
I don't
there's a
think-
VOP.
I think so. I don't see a VOP pending.
Yeah,
I see, on that
he
case
is on
number.
probation.
Yeah, and on the PC itself, when it came into magistrates, it looks like it came in for,
He's counting sentences on the VOP.
Your Honor, I seen Judge Yusan yesterday. I'm
Okay,
sorry,
hold on there. Yes, what? Okay, all right. All right, so I hear what you were going to tell me. I've been informed that you were sentenced on the VOP until December 26th. Is that right? All right, so you have this petty theft case.
And Judge Yusan reinstated me yesterday. I just seen him yesterday, Your Honor.
Okay.
I have the paperwork right here.
No, that's okay. They've told me. It's been confirmed.
Yeah,
So what do you want to do with this petty theft case?
I want to resolve this case, Your Honor. Throw it out.
Well, I'm not throwing it out if you mean dismiss it.
It was,
But you
I
can,
bought- I
but
bought
there,
the drink, Your Honor, and then they said that I supposed to pay for refill, which I had no idea.
Mr. Acevedo, do you want to resolve this charge this morning or this afternoon?
Yes, yes.
All right,
yes,
then
Your
listen
Honor.
carefully to what the judge says.
well, just I
okay?
want you to understand, it sounds like you may say that you have a defense. This is not me dismissing the case and throwing it out, because I don't have, I have not done any investigation. I don't do investigations. That would be
Yes, sir.
between you and your attorney. So if you want to further investigate the case, if you want to go to trial because you have a defense, then that's something else for another day, not for me. Do you understand that?
Yes, Your Honor.
If you want to resolve the case, which means if you want to take a plea on the case, then I can do that today.
Yes, Your Honor. I want to resolve this case.
All
'Cause,
right.
Mr. Yusan, Your Honor said that I can just not go to 7-Eleven again, and that's what he said.
All right, so then I'll sentence you to time served, and I'll also back up what Judge Yusan says and tell you no return to that 7-Eleven.
Yes,
All
Your Honor.
right.
You won't see me there again.
All right, well, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, Your Honor.
All right, you can put your hand down. And do you understand everything we've discussed here today?
Yes, Your Honor, I do.
Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
no, ma'am.
Do you-
Not at all, Your Honor.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your
And,
Honor.
and do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter, sir? Guilty or no contest?
No contest, Your Honor.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck.
Good luck,
I-
Paul.
Ayana McKeithen. Thank you. All right, Ms. McKeithen was arrested on December 16th. This is on a touch or strike battery or resisting without violence. She has a $1,000 bond.
Yes, Your Honor. Mr. McKeithen indicated to me that, I'm sorry, Miss McKeithen, sorry, that there is no way that she's going to be able to post that bond, Your Honor. She is asking for pretrial release if the court would consider it. She has been a resident of South Florida all of her life. She has lived with her mother since last year. She's been living with her mother for a year. And she is planning on enrolling in Broward College next year to study law.
And are there any priors to consider?
Judge, besides juvenile priors that I can't put on won't put on the record now. According to Florida CCIS, Your Honor, I looked up the defendant under that name, and the birth date that pops up is 8/10/2000, and she has an open, it looks like in Palm Beach, Grand Theft Auto that was filed on the date of October 2nd, 2019. The case number that's popping up is 50/2019 CF008629 A-XXXMB. I'll just ask you to keep the bond the same, Your Honor.
So this case is in Palm Beach, that's pending.
That's pending, that's what it looks like.
All right, so, Ms. McKeithen, I'm going to leave your bond in place at $1,000 on this case. All right. John Isma,
North Broward?
all right, so then we'll delete that hearing. Mary, Exantus Jean Mary. Okay. All right, so Mr. Jean Mary has got a DUI. How much bond does he have? He has $2,000 in bond. Oh, thank you. All right, what do we need to know about Mr. Jean Mary? Did he have priors? No, up until now, he had a valid driver's license, so. Looks like he had a valid driver's license. I'm not,
Can you find any priors for him? I can't find any. Jean Mary, I can't.
I know in 2009, he had a DUI. And a refusing to submit. So he had a DUI back in 2009 for his driving record, but I guess he got his license valid. I will release Mr. Jean Mary to DUI, pre-trial supervision, and that's going to include random drug and alcohol testing. Standard. Well, hold on just a moment. Let me just look at his driving record again, if it was, oh, that one he refused. The previous one he refused. This one he blew a .211 or 205. Let's make it with a tab. Okay? All right.
Is that TAD?
Huh? No, you're right, just a tab. Okay. All right, so, sir, in lieu of the bond, you will be on pretrial supervision, and you'll also have a TAD monitor to monitor no drinking and driving, okay?
Yes, ma'am.
All right, sir. Mr. Jean Mary, do you have a permanent address?
Yes, ma'am.
That's all you need to know? Okay, all right, sir, good luck.
Thank you.
All right, I believe that's the end of our hearings.
Boy, I miss being